Let us start. Good afternoon, Mr. Gough.
Good afternoon, Acting Chief Justice, members of the Commission.
How are you this afternoon?
To say I wasn't a little nervous would be to tell a fib, I think, Acting Chief Justice.
Now, relax. Relax. You are going to enjoy the interview. Thank you for coming to this session of the Commission's interviews, Mr. Gough, and thank you for making yourself available for consideration for appointment as a judge of the Eastern Cape Division of the High Court. I see that you hold a BA and LLB from is it
Rhodes University, Acting Chief Justice.
West University.
Rhodes.
What university?
Rhodes University, Acting Chief Justice.
Oh, yes, okay, thank you. And you got them in 1980 and 1982, respectively.
That is correct.
And you started your career in law as a prosecutor.
For a very brief period, Acting Chief Justice, it was a holding phase of my life. I prosecuted for 3 or 4 months at the beginning of 1984.
Yes, and thereafter you went to do articles.
Yes.
And you were admitted in 1986. Is that correct?
August 1986.
Yes, and thereafter you practiced as an attorney for quite some time after that.
From 1986 until date, Acting Chief Justice.
And that makes it how many years?
37 years.
That's quite long. So you have a lot of experience.
I have been fortunate to have many years of experience acting Chief Justice.
Yes. Can you tell us what types of cases you have had to deal with in your practice over these years?
Acting Chief Justice, I've been very fortunate, and perhaps growing up in a city such as Port Elizabeth, where one can't afford the luxury of specialization, I've been exposed to almost all aspects of legal practice. As a young article clerk, as one is wont to do, you start off in debt recoveries. It teaches you how to stand on your feet and work your way forward. Recovery of damages, insurance claims, family law, professional negligence claims. And as my practice developed, I became more and more involved in commercial law matters and in public law and administrative law matters. But I've also had the privilege of being exposed to competition law matters. We'll see from my curriculum vitae that I was involved in a large collusion matter in which I handled from right from the investigative stage through to an appeal to the Supreme Court of Appeals. I've been involved in liquidations, interrogations. I've had some exposure to interrogations under the Tax Administration Act. But principally over the last 20-odd years, I guess my practice has focused primarily on public administrative law, which has involved obviously constitutional issues, some constitutional challenges on legislation, and then also I've been involved in complex commercial matters. But aside from that, I've also, and I believe it's an important foundation in one's practice, I've been involved in commercial law. For instance, I was the in-house legal advisor essentially the in-house legal advisor from cradle to grave for the construction of the stadium in Port Elizabeth. I have been involved in the development of sustainable energy projects, all of which have stood me in good stead for my practice, which has largely been founded on commercial litigation and public law.
Yes, and I see that there's a long list of cases in which you have been involved that have been reported.
Yes, Acting Chief
Is
Justice.
that right? And there is one in the Constitutional Court, and there are quite a few in the Supreme Court of Appeal, and I say quite a few, maybe that's about 10, I'm not sure.
Yes, Acting Chief Justice.
And then in the High Court, you may be having about 12 or 15 or thereabout. Is that right? That's more or less right.
That is more or less correct, Acting Chief
Yes.
Justice.
Now, in your practice, did you actually do appearances yourself as in terms of arguing cases and doing trials, or did you always brief counsel for purposes of arguing those matters and conducting trials and attending inquiries? What was the position?
In the earlier stage of my practice, Acting Chief Justice, I personally appeared. I personally appeared in criminal matters, civil matters, insolvency inquiries and the like. But as my practice evolved and the matters became more and more complex, I involved counsel more often. I've, for instance, personally argued matters in the Labour Court. But I don't believe that I could give justice to my client's needs and requirements by personally appearing, but at the same time doing the long, hard hours of preparing a case properly for trial.
Is that simply because you prefer to play that role as an attorney and have counsel rather than do both? Because obviously those attorneys who appear and present argument or conduct trials do both the preparation and the strategizing for a matter, for a trial, and actually the execution of the plan.
I think the nature, the way that my practice has evolved, Acting Chief Justice, I would never have been able to do justice with the size of the matters and to prepare and then spend 2 or 3 weeks in court, but at the same time still prepare and manage other matters.
Yes.
It's the way my practice evolved. It's not to say that I don't enjoy or did not enjoy when I did it, standing on my own 2 feet and strategizing and running the matters myself.
Yes. Would the position be that if it's a big trial, such as one that could take 2 weeks or 3 weeks, you would spend most of the time in your office because you have to manage other matters and then get somebody else, maybe a junior attorney, to be with counsel in court or a candidate attorney? Or would you also be with counsel throughout that kind of period?
It would typically depend on the nature of the matter, but if it was a significant matter, I would obviously prefer to be in court because the use of counsel is not, you don't pass the buck the moment the trial starts. You have to develop your strategy and ensure that your counsel are doing what you've strategized over, to pick up the nuances of the court, to see, you're better positioned often to observe the responses of witnesses. And it's that type of first-hand knowledge which assists counsel during the tea adjournments or after hours when you're discussing the matter. And also in ensuring that when you give feedback to your client, you can tell them firsthand what has been happening.
And you've had a chance to act as a judge in the High Court as well?
Yes, Acting Chief Justice.
Yes, and how long have you acted?
It was a short stint. It was 6 weeks from October 2019 until the first 2 weeks in November of that year.
Yes. And how did you find it?
When the JP first approached me, Acting Chief Justice, I thought, what is this experience going to be? Will I be equipped for it? Will I be able to manage it? And I thought to myself, I must give myself an opportunity to experience life as a judge. So at first hand it seemed challenging, but from the moment that I walked into court, I realized that not only was it challenging, but it was also, for me, a new experience to learn and grow within myself, and to appreciate that, yes, you do have the skill sets to do the job.
Yes. And you did both civil trials and criminal trials and motion courts.
I wasn't exposed to criminal trials, but I did criminal appeals and I did a bail appeal in Bishu.
Yeah, and motion courts?
I was the duty judge for 3 of the weeks, 2 in Grahamstown and 1 in Bishu.
Yes, okay. Judge President.
Thank you, ACJ. Good afternoon, Mr. Gough.
Good afternoon, JP.
I must say I was impressed when I read your CV. It is really attractive. And then you acted for 6 weeks, yet you were so productive that, according to what appears at pages 18 and 19, which is basically a grid setting out judgments that you penned, within that 6-week period, you were able to write 8 judgments in opposed applications. And I see one was from the unopposed court, one was an urgent application. You ran 2 civil trials and you penned a judgment, a criminal appeal, 2 civil appeals, 1 bail appeal, 2 applications for leave to appeal, and 1 criminal review. Would you confirm that as being the accurate state of play?
Yes, JP. I think in total there were 16 judgments that I wrote over the 6-week period that I sat.
You've been afforded the opportunity to act once again during the current term.
Yes, JP, and as I say, you graciously gave me two days off to attend this interview.
And thank you. Are you familiar with the concept case flow management?
Yes, JP.
Yes. Do you know why it took some time for case flow management to take root in Grahamstown and Port Elizabeth, and was embraced in Mthatha and East London, Bishop?
JP, I don't know the history as to why it took so long, but I don't understand the resistance to it. I think it's fundamental to ensuring that our courts are not bogged down by matters being put on the roll and then not being expediently dealt with. I believe the public is entitled to have their matters disposed of expediently, but I can't say that I'm aware of the reasons for the resistance to it.
But now that it has taken root, are there any regrets on the part of the practitioners, both in Grahamstown and Port Elizabeth?
I can't speak for.
You have not sensed that.
I can't speak for Grahamstown, but for me personally, in Gough, what it means to me is that attorneys need to apply their minds to matters earlier. And if there's grumbling about that, well, so be it. If they've got to do a bit more work or a few more hard yards, then that's what's required of them.
Yes. Thank you very much, ACJ.
Thank you, Judge President. MEC Gade, if you have questions for the candidate, I give you a chance to ask him now.
Thanks, SJ. I don't have a question thus far.
Thank you very much. Any questions, commissioners? Commissioner Noketsi.
And Afternoon, Mr. Gough.
Good afternoon, Commissioner.
I see that in 1984 you were already.
Please speak up, Commissioner.
I see that as early as 1984 you were already an admitted attorney.
No, I was admitted in August 1986, but I was prior to that for a very brief period for the purposes of when I was a prosecutor admitted as an advocate for a very short period.
Now, since your admission, how many black practitioners or candidate attorneys have you afforded an opportunity, either in your previous firm or in your own office?
I haven't kept statistics, Commissioner, but I can say that we have our firm has employed any number of black candidates, and we started that practice from the late 80s into the early 90s. I can't give you the statistics, but I can say that our employment practices, certainly over the last 10 to 12 years, have meant that we have predominantly employed black candidates.
I'm saying in your name, a candidate attorney is registered under a director. You as a director, who are the African attorneys that were registered under your name in a firm? Just if you do have.
I have not personally had any candidate attorneys registered in my own name since probably 1990, Commissioner. So I have had no black candidates myself registered in my name.
Let me simply put it this way. Since you were admitted, a director like myself, once I'm admitted, I should register at least a maximum of 3 candidate attorneys. That is part of entrance to the profession. I'm saying you, as a person, have you ever registered a single African?
I've already answered that, Mr. Commissioner. My answer was no.
Yes. Then that would have been your contribution in terms of transformation. That would be a direct contribution. Put aside that one of briefing black advocate, but just to have an African who have been so excluded for so many years, just register. When you look back on that, would you regard yourself to having contributed in the transformation of within the profession?
Yes, Commissioner. I don't believe that the registration of candidates in your personal name, in your own name, is a measure of your contribution towards transformation. The fact that I have not had candidate attorneys, whether they were black or white, registered in my name since then is I don't see that as being a basis on which to conclude that I have not contributed towards transformation.
My problem is that once we say black or white, I'm not talking about black or white. I'm concentrating myself on Africans who have been so excluded, particularly in areas such as the area where you come from. Very few firms run by African practitioners. Would you not say, when you look back, you sit here, say, as little that I could have done would be this, that is, allow some access to the profession by this way, because that's what the legislation allows you to do. That's the emphasis, that you can take at least a minimum at a time in a period of 2 years. That's 3, only 3, under your own name as a director.
I don't know that I can take the answer any further than I have, Mr. Commissioner.
Okay.
But I freely recognize the hardships and the imbalances and the prejudices that in particular Africans have been through. But I don't believe that that the fact that I personally, as opposed to my firm, have not employed black candidate attorneys is reflective of my commitment to transformation.
I may have missed something earlier on, Mr. Gough. Is the position that over the 37 years that you have been in practice, you have never taken an African or black candidate attorney under your wing and registered them, but the law firm has done that, but not attached to you personally? Is that the position?
Acting Chief Justice, if I can maybe explain it this way, is that the registration of a candidate attorney in the name of one of our directors or one of our professional assistants is not reflective of how we manage or run our practice.
Yeah, no.
So the question, the answer to the question,
I want to get the facts right first.
Yes.
I want to get the facts right.
Yes, as I've said, I have not myself personally had a black and in particular African candidate registered in my name.
Have you had a candidate attorney who is not black registered in your name or in the 37 years?
As I've said, Acting Chief Justice, I have not had candidate attorneys registered in my name since the early 1990s. It's not the way that the practice has evolved. So prior to that, the answer is I don't recall offhand, but probably not. I don't know. I have not kept records.
You started practicing from, was it 1986?
1986.
86. So the period that you are sure about, that you never had a candidate attorney of whatever color registered in your name, is from 1990 up to now.
I would say that that's an approximation. As I've said, I
more or
have not
less,
kept
more or
records.
less.
Yes.
But before 1990, you think maybe you did. But no, it would not have been a black or African if it happened.
I can't say with any certainty, Acting Chief Justice. It's not something that I've kept records or been particularly mindful of.
Yeah, no. If from 1990 up to now, you never took any candidate attorney under your name, whether black or white, there is no way you would not remember a candidate attorney that you would have taken between 1986 or 87 to 1990. You would know the only candidate attorney you ever took was so, because it would be one or two.
As I say to you, Acting Chief Justice, as I said to you, in all probability not, but I can't say with absolute certainty because I have no record.
But if the law is still the same, when I was in practice, you, as an attorney, you were not allowed to take an article clerk until you had completed at least 3 years of practice. So if you were appointed if you were admitted in 1987, you would only have qualified to take an article clerk in about 3 years later, around 1990. If you say you are certain that more or less from 1990 up to now, you have never taken an article clerk or candidate attorney, whether black or white, it probably means you have never taken
as I've said to you,
all.
As I've said to Acting Chief Justice, that is indeed so.
Yeah, it's quite extraordinary. Yes. You want to follow up?
Just a follow-up.
Okay.
Sorry, with your leave.
Okay.
Now, in the matters that we have, for instance, the one that went to Constitutional Court, or 10 that were in the SA, 10 matters in the SA, you mentioned, who were the African advocates that were briefed? Just name one.
There were none involved in the Constitutional Court matter.
in the SA 10 matters?
No, we did not use.
Now, I'm asking you these questions simply because the preamble to our constitution dictates that we must heal the division of the past, and among the other instructions is that we must free the potential of every citizen. Would you regard yourself as having been committed to this constitutional undertaking or value, founding value of our constitution? Are you committed to the constitution?
Yes.
But you just yourself admittedly, in your own practice, something that would allow access by those that were previously disadvantaged, you take no steps. In your matters that you brief, you just brief none. Thank you very much.
Thank you. Just to make sure, at least I understand the position, we referred earlier on, Mr. Gough, to the many reported cases that you have listed in the questionnaire in which you were involved, some in the High Court, others in the Supreme Court of Appeal, and one in the Constitutional Court. Is the position that in none of those cases did you ever brief a black counsel, or in particular an African?
I believe that is probably the position, is Acting Chief Justice.
Yes. Okay, all right. Commissioner Mpofu.
Thank you. Good afternoon.
Yes.
He's
Sorry.
here.
Thanks. This side.
Yes.
Thank you. Yes. No, just out of interest, when you served in the South African Defence Force in 1982 to 1983, what kind of duties did you perform?
I was a military law advisor.
Where? Based where?
Where?
No, I'm just saying based where, just in case maybe we met by accident.
No. I spent 6 months in then Southwest Africa, and 6 months in Grahamstown.
Okay, thank you.
I must mention this, Mr. Gough, just so that we don't have a situation where I take your answer that you have given to my question arising out of the questions from Mr. Nojesi in a certain way, and I make a certain inference without giving you a chance to say, to understand and maybe say why I shouldn't make that inference.
I think, Acting Chief Justice, it is indeed so that on the face of it, the briefing patterns may seem and are skewed, but it also doesn't take
Allow me to tell you what I want to put to you. Then you'll get a chance to say whether I should see it that way. You have in the country white advocates, you have got black advocates that you can use, you could use over 37 years of practice, and you only used white advocates and never used black advocates over so many years. Is it because you did not have confidence that black advocates could do the job?
Well, firstly, Acting Chief Justice, it's not correct that I have not used black advocates. They might not reflect in the reported judgments. Yes.
Have you used them in matters other than those that are reported? Because I thought Mr. Nojesi gave you a chance to indicate even just one.
No, I understood his question to be talking. He specifically said in the Constitutional Court and and the reported matters. So
Yeah,
the answer is yes.
Yeah. Yes, you have used them.
I have briefed black advocates and, in particular, African advocates in matters.
Yes, are you able to give us their names, or some of them at least?
Yes, Advocate Nkatuba, Advocate Pango, Advocate Nati Gaisa, Advocate Kamana. I don't recall offhand the names of others, but I have made use in the same. I have made use of Black Council. Yes.
And would you have made use of them in matters that went to court, or only in regard to opinions?
No, they've been used as juniors in trial litigation and in arbitrations. They've been involved in the drafting of papers. They've been involved in all aspects of the matters that I've been involved in. Now it springs to mind. I've briefed Advocate Bevan Boswell, Advocate Katesh Gadjar, to name a few. I have, but it's not a confidence issue at all. Acting Chief Justice.
Yes. Okay. Is the position that they were used as junior counsel and were led most of the time or all the time, or it was a mix? Sometimes they were not led; they were the lead counsel.
I would say the significant majority of the matters that I've been involved in over the last years have involved senior counsel.
Yes.
So they have been led by seniors.
Yes. Okay. All right.
But I've also used junior counsel themselves for matters.
Yeah. Okay. All right. Thank you, commissioners on the virtual platform. Any questions?
Yes.
Yes,
Justice.
Commissioner Barnard.
Thank you. Good afternoon, Acting Justice.
Yes, good afternoon, Commissioner.
My concern goes to a concern raised by the LSSA about cost orders. You know, the fact that judicial discretion is quite an important discretion, and there's some question marks raised about cost orders. If you want to, you can comment on any of those that they refer to, but I want to refer specifically to limit the question just to one matter, and
yes.
That is the matter on page 113 of the bundle, which is a matter where the successful litigant who acted on behalf of a 3-year-old minor was ordered, was penalized with a cost order. So basically, if one takes it on that basis that no costs were awarded in a successful claim, which ultimately means that the 3-year-old would have borne the brunt of the costs in that matter. It's not that you made a cost order against the erring practitioners or specifically against the litigant. And the point is made that is quite a harsh exercise of discretion.
Yes,
considers an injured 3-year-old child.
Yes, I've reflected on that, and I've taken I've made a note of that comment, and I've also thought myself back into the position in that particular matter. I was not privy in that matter to the discussions between the plaintiff and the guardian and the plaintiff. I was not. The matter should never ever have been commenced in the High Court. The matter was ultimately resolved on an undertaking given for, I think, with a value of some 10 or 15 odd thousand rand. The matter was run right up to the doors of court. The matter, when it was argued in front of me, the significant majority of the costs would have been incurred in arguing the costs themselves, and in that particular instance, the counsel appearing for the plaintiff in that matter was acting pro amico. So the only costs that the plaintiff did not secure were very limited party and party costs on the magistrate's court, which would have been all but insignificant, and I was not aware of the relationship or how that matter had evolved. It was also only through my assessment of the matter that I put myself into a position to challenge the role which the road accident funds had played in that matter, in not accepting in the matter earlier, and in also not themselves qualifying experts at an earlier stage. But again, at the time and in the moment, I considered that to be a fair reflection, and I don't know what ultimately happened as between the plaintiff and the guardian of the minor, but I don't know. I can't comment. As regards the other two matters, the one matter was where a judicial officer had taken on review belatedly a decision taken by a colleague, and had made fairly defamatory remarks not only about the colleague, but also had impugned the office that she sat in, and it was felt, I was of the view that it was worthy of a punitive costs order, and a very senior judge sitting with me in the matter agreed with that conclusion. As regards the other matter where I ordered costs on an attorney-client scale, well, that's precisely what the contract provided.
Thank you, Acting Justice. Thank you, Acting CJ.
Thank you very much. I think we have reached the end of this interview. Thank you very much, Mr. Gough, for availing yourself.
Thank you.
Thank you very much, and you are now excused.
Thank you, Acting Chief Justice, members of the Commission.
Thank you very much.